Do not put your children on the deed to your house. I tell people this time and time again. Some of them listen, some of them don't. I get it, folks. Nobody likes lawyers, usually for a good reason, and nobody wants to pay legal fees or wants to pay for legal advice. So what do? They do it themselves. And oftentimes, they screw it up. In the state of Florida, if you were to add a child to your deed, if you do not use the magic language that creates rights of survivorship, then upon your passing, you have created something called tenants in common. With tenants in common, when you die, your 50% ownership has to go through probate. So you just defeated the purpose that most people try to put their kids on their deed for, is to avoid probate on their house. Second thing, if you add your child as an owner to your house, then down the road, you want to sell it, gift it, rent it, mortgage it, reverse mortgage it, your child has to agree, and they can hold you hostage by not agreeing to allow you to put more debt on their future inheritance. Another problem is that in the state of Florida, we have wonderful homestead protection laws. So if you get sued, most likely your creditor can't take your house away from you. However, if your child doesn't live with you, which is often the case, and they get sued, their ownership interest in your house may be levied or liened by their creditors because they don't live in the house and therefore don't have the Florida constitutional homestead protections. Finally, taxes, specifically capital gains income taxes. We have lots of families here that happen to strike it lucky and they bought a house back in the 1940s, 50s, 60s. They maybe paid 30 grand for it. And now, because it's in a desirable location, it's $2 million. Well, if you add your child to your home, under the IRS rules, they take what's called a transferred basis. So the day after you die, if they sell your home that you paid $50,000 for and it's now worth $2 million, they're paying income tax, capital gains taxes on that entire spread at 20% using today's calculations. If you leave it in a ladybird deed or in a trust, then they get the only gift the IRS ever gives us, which is a step up to fair market value on the date of your death. If they sell it for $2 million the day after you die, they pay zero in capital gains income taxes. So the moral of the story is, don't be your own lawyer, don't do your own deed work, and don't put your children on your deed as owners. There's lots of ways to avoid probate, leave the house to them, and get preferential tax treatment. Thanks. Have a great day.